This is going to be 4 minutes at 2:20 straight through, ready to write. I've mentioned the word evidence. Evidence includes the testimony of witnesses, documents, and other things received as exhibits, any facts that have been stipulated, that is, formally agreed to by the parties. Certain things are not evidence. I will list those things for you now. Statements, arguments, questions, and comments by lawyers are not evidence. Objections are not evidence. Lawyers have a right to object when they believe something is improper. You should not be influenced by the objection. If I sustain an objection to a question, you must ignore the question and must not try to guess what the answer might have been. Testimony that I strike from the record or tell you to disregard is not evidence and must not be considered. Anything you see or hear about this case outside the courtroom is not evidence unless I specifically tell you otherwise during the trial. Furthermore, a particular item of evidence is sometimes received for a limited purpose only. That is, it can only be used by you for one particular purpose and not for any other purpose. I shall tell you when that occurs and instruct you on the purposes for which the item can and cannot be used. Finally, some of you may have heard of the terms direct evidence and circumstantial evidence. You are instructed that you should not be concerned with those terms, since the law makes no distinction between the weight to be given to direct and circumstantial evidence. In deciding what the facts are, you may have to decide what testimony you believe and what testimony you do not believe. You may believe all of what a witness said, or only part of it, or none of it. In deciding what testimony to believe, you may consider the witness's intelligence, the opportunity the witness had to have seen or heard the things testified about, the witness's memory, any motives the witness may have for testifying a certain way, the manner of the witnesses while testifying, whether the witness said something different at an earlier time, the general reasonableness of the testimony, and the extent to which the testimony is consistent with any evidence that you believe. In deciding whether or not to believe a witness, keep in mind that people sometimes hear or see things differently and sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent misrecollection or a lapse of memory or an intentional falsehood, and that may depend on whether it has to do with an important fact or only a small detail. You may hear testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinions on matters in the field and the reasons for their opinions. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all other evidence in the case. Also, an expert witness may be asked to assume certain facts are true and give an opinion based on that assumption. That is called a hypothetical question. If any facts assumed in the question are not proved by the evidence, you should decide if that omission affects the value of the expert's opinion. Plaintiff and defendant have agreed or stipulated to certain facts and have reduced these facts to a written agreement or stipulation. Any counsel may, throughout the trial, read to you all or a portion of the stipulated facts. You should treat those stipulated facts as having been proved. Certain testimony from a deposition may be read into evidence or played from a videotape. A deposition is testimony taken under oath before the trial and preserved in writing or on videotape. Consider that testimony as if it had been given in court. During the trial, you may hear the word interrogatory. An interrogatory is a written question asked by one party of another. You must answer it in writing under oath. Consider interrogatories and the answers to them as if the questions had been asked and answered here in court. From time to time during the trial, I may be called upon to make rulings of law on objections or motions made by the lawyers. It is the duty of the lawyer for each party to object when another party offers testimony or other evidence that the lawyer believes is not properly admissible. You should not show prejudice against a lawyer or the party the lawyer represents because the lawyer has made objections. You should not infer or conclude from any ruling or other comment I may make that I have any opinions on the merits of the case favoring one side or the other. Also, if I sustain an objection to a question that goes unanswered by the witness, you should not draw any inferences or conclusions from the question itself. During the trial, it may be necessary for me to talk with the lawyers out of your hearing, either by having a bench conference here while you are present in the courtroom or by calling a recess.